Get ready for a legal dictation. 5 seconds. Start. The other grounds urged by Sri I.D. Shukla is that even assuming if the benefit of Section 5(3) (b) of the Act of 1960 was being withdrawn, even then it was incumbent upon the authorities to have taken notice of the offer which had been given by the petitioners in terms of Section 12A of the Act of 1960 (star). It has also been submitted that the provisions of Section 12A of the Act of 1960 ipso facto apply to the proceedings under Section 13A of the Act of 1960 as provided in Section 13A(2) of the Act (star). This aspect of the matter has not been considered, and thus, the order impugned deserves to be set aside (star). Learned Standing Counsel, while defending the aforesaid order, submits that in the first round of litigation, initially at the time of determining of the surplus land insofar as the petitioner is concerned, there was an objection by Ras Bihari Singh contending that he was a major staff. Initially, the prescribed authority had passed an order which did not consider the age of Ras Bihari Singh, and thus the appeal filed by him was allowed and the matter was remanded to the prescribed authority for determination afresh, including to determine the age of Ras Bihari at the relevant time (star). Therefore, upon the fresh determination, it was found that so far as the petitioner Ras Bihari Singh is concerned, he was a minor, and this aspect of the matter was taken by the Ras Bihari Singh by filing a writ petition before this court, which came to be dismissed on 23/8/1984 (star). Thus, the aforesaid issue holding that Ras Bihari Singh was a minor was no more open to be urged, and accordingly the first ground raised by the petitioners failed (star). It has also been urged by the Learned Standing Counsel that admittedly no gazetted notification in terms of Section 14 of the Act was made, hence, the limitation as referred to by the petitioner also did not come in the way of the prescribed authority to initiate the proceedings under Section 13A of the Act of 1960 (star). Since the benefit given to the petitioner on incorrect facts and to which he was not entitled, this being an error apparent on the fact of the record, hence it was rightly redetermined by the prescribed authority (star). Learned Standing Counsel further submits that the option exercised by the petitioner in terms of Section 12A of the Act of 1960 was also taken note, since the prescribed authority has taken the land from Karam Mohan village, as has been opted by the petitioner, in the aforesaid circumstances, the writ petition on both the counts deserve dismissal (star). The court has considered the rival submissions and also perused the material on record (star). Insofar as the first ground raised by the Learned Counsel for the petitioner is concerned, that does not appear to have any merit, inasmuch as the Learned Counsel could not dispute the fact that at the relevant time Ras Bihari Singh was found to be minor (star).